Our topic is debt collection and the regulation of legal tech in Germany. We will learn how legal tech companies are presently regulated in Germany and about the new law that the German government proposes to promote, consumer-friendly offers in the legal services market. How will this impact legal tech companies? And most importantly, why is this relevant for legal protection insurers? I am Antje Fedderke, Secretary General of Legal Protection International. Our speaker will present between 30 to 40 minutes. At the end of this presentation, we will have a Q&A session. You can use the chat function to ask questions, and Mr. Hartung will answer these during his presentation or afterwards during the Q&A. The speaker's PowerPoints and a recording of this session will be available afterwards. Before we start, I want to remind you of our 2021 Congress. A Brave New World, the Future of Legal Protection Distribution. We will actually meet on 28 and 29 October in beautiful Vienna. And if you prefer, you can also join virtually. The Congress is all about new and inspiring ways to market and distribute legal protection insurance. We will explore the new normal and discover new paths to recovery after the COVID-19 pandemic. So sign up, and I'm hoping and looking forward to seeing you in Vienna. Now, I am happy to present our speaker today. Please welcome Markus Hartung. Markus, you can show your face if you like. Markus Hartung is lawyer in Berlin and founder and senior fellow of the Bucerius Center on the Legal Profession at Bucerius Law School in Hamburg. Until 2019, he was chairman of the Committee on Professional Regulation of the German Bar Association, and he is also co-founder of ELTA, the European Legal Tech Organization. Twice, and the last time very recently on 5th of May, the Legal Affairs Committee of the German Bundestag invited Markus to present his expert opinion on the modernization of the regulation of legal services. I am extremely proud to have a renowned expert here today. Markus Hartung, the floor is yours.
Thank you, Antje. That was a very kind introduction. Guys, I'm speaking over a speakerphone, and I do hope that everything works well with light and sound. If not, please shout. Now let me see whether I can just show you my slides, and then we're off to it. So you should see that now. Okay, well, this is a bit of an ad just to show what we have done with regard to legal tech. But today we're speaking about debt collection in CASO and the regulation of legal tech in Germany. And as Antje said, I will speak about 30 to 35 minutes. And I want to introduce to you the concept of the legal market and how legal tech fits in the roster of legal service providers, and whether they fit in or not, and why it is a very contentious issue, and why lawyers are partly dead against it. And we will speak about this reform and this proposal, and about that, what we can expect and what we can probably not expect. To start with, we are talking about a Gesetzesentwurf der Bundesregierung. And in Germany, you see it, Entwurf eines Gesetzes zur Förderung verbrauchergerechter Angebote im Rechtsdienstleistungsmarkt, the Draft Act on the Promotion of Consumer-Oriented Offers in the Legal Services Market. I mean, who could be against that? the promotion of consumer-oriented offers should be something where everybody says, of course, we are in favor of it. But still, it is a very, very contentious issue because this draft act means to go for contingency fees for lawyers and to sort of loosen the regulation for lawyers. And on the other hand, bring forward a better regulation for legal tech companies, or always as debt collection companies, but I will explain you in a minute why that is the case. So, and where are we at the moment? Today, really, literally an hour ago, there was an article in LTO, Legal Tribune Online, and it was reported that Koalition einigt sich auf Erfolgshonorare. So the governing parties, Christian Democrats and Social Democrats, have found an agreement and want to bring this forward. It has not yet been in Parliament, and it is not yet the law. But you know, if nothing goes wrong, then we should expect that, say, at the end of this year, we will have a new law on legal tech, consumer protection, and for lawyers. So how does that all fit in? Let me just give you a brief introduction how things in Germany are regulated. It all comes down to the Act on Out-of-Court Legal Services. That's the Rechtsdienstleistungsgesetz. And basically, it all starts with a general prohibition. It says the independent prohibition of out-of-court legal services is permissible only to the extent provided for under this Act or by or pursuant to other laws. So that is a general prohibition with the reservation of permission. We call it in German Verbot mit Erlaubnisvorbehalt. This sort of prohibition, I mean, this law stems from 2007. Nowadays, they are very rare. The concept has changed. You normally allow something and reserve the right to prohibit it in case any dangers come up. But that in that regard, this law says no one is allowed to provide legal services unless this law provides. And this is of course a restrictive regulation or provision with regard to our basic law. We call it Grundgesetz. It's not our constitution. It's a sort of interim constitution which says all Germans shall have the right freely to choose their occupation or profession, the place of work, and so on and so on. And of course, to provide legal services is exactly that. So, you know, in Germany, providing legal services is seen as something which is so important, and the quality of that is so important that it is very strictly regulated. And why is this? In Section 1, this Act says it serves to protect the consumers of legal services, the legal relations, which is the Rechtsverkehr in German language, and the legal system from unqualified legal services. That is the German standard. That is not the European standard. There are quite a number of countries in Europe which have a pretty different set of regulations. Switzerland, for example, out-of-court services in Switzerland are not reserved to lawyers or are not regulated to that extent. In England, the situation is different. In the Nordic countries, it's different. Germany is still, say, tightly regulated, and as we sometimes tend to think that that was the best thing on earth, it helps to look over the borders to see how the world also could look like. In Germany, it's very strict, and it's reserved to lawyers and to other registered legal service providers. So this Section 3, which generally prevents or prohibits the provision of legal services unless explicitly allowed under this Act, it has a general permission for lawyers who, under the Federal Lawyers Act, are the appointed and independent advisors and representatives in all legal matters. So, and that is, you know, that is the main concept in Germany. Legal services mainly provided by lawyers, and only in exceptional cases by non-lawyer legal service providers. So, And that is the Rechtsdienstleistungsgesetz, the Legal Services Act, intended to achieve, to protect consumers. What is the REG not intended to achieve? It is not a law to protect lawyers before any competitors, although many lawyers would claim that this Legal Services Act is a sort of protective set of regulation for them. But that's explicitly not the case. So it's really only to protect consumers in order for them not to get unqualified legal services. So what is a legal service? Legal service, any activity related to the concrete affairs and so on and so on. Of course, you need a definition of that if you want to forbid it or allow it. And the interesting thing, and the question which always comes up is how broad do you interpret this, or how narrow do you interpret this? The broader the interpretation is, the more providers you keep out of the market and reserve that for lawyers and non-lawyer service providers. And the issue is that following a decision of the Federal Supreme Court from 2016, they have taken a very expansive view of the term legal service. They say it covers every concrete subsumption of a factual situation under the relevant legal provision, beyond a mere schematic application, and whether this is a simple or difficult legal question is irrelevant in this regard. So that means even, legal questions where you would think, well, you don't have to go to university to know that, these can be considered as or regarded as legal services which are reserved to lawyers. And the question which immediately come up, what is with services which are purely provided by computers or by software? So is that not just a schematic application of the law? Because software is 1 and 0. It's yes or no. It's not, judging situations is not the easiest thing for softwares. So is the pure application of legal services provided by software, as LegalZoom is doing that in the United States, or Smart Law is doing that in Germany, is that a legal service which only is allowed to be provided through special service providers? The jury is still out on this. There is one decision of the Oberlandesgericht Köln, which took the view that the provision of legal services through a software is not a legal service. But at the end of June, the Federal Supreme Court will deal with this. But that's a very difficult question, whether or not, and for LegalTech, it plays an important role. So there are some exemptions from the general prohibition of Section 3, which is ancillary services in Section 5. We are not going to talk about this. And there are free legal services and then professional associations and interest groupings and cooperatives, or Verbände, Kooperativen, and public and officially recognized bodies. So the Public Consumer Protection Agency, they are allowed to provide legal services, but these are exemptions from the rule, and there are not very many providers like that. In Germany, the unions are the strongest representatives in that group. And of course, there are the so-called registered persons, which are allowed to provide non-lawyer legal services once they have achieved a registration or a license through the relevant authorities. And these are in particular so-called collection services, incasso services. So companies which claim money from someone to give it to your client. And collection services actually is a term where you could discuss whether you want to interpret it more broadly or more narrowly. But that is the general concept of the Legal Services Act. Now, what about legal protection insurers in Germany? The situation is the situation is pretty bad for legal protection insurers because the law does not allow for legal protection insurers to provide legal services. Well, the law doesn't have an explicit provision saying that. Even the term legal protection insurers, or Rechtsschutzversicherer in German, is not part of the law, but there is a section 4 saying incompatibility with another obligation to perform. And that is a provision which stems from a verdict of the Federal Supreme Court from the year 1961. And the court said, look, if there is someone who provides legal services for his policyholder, then there is a conflict of interest because the policyholder has an interest that his representative, his legal representative, does everything he can to pursue his right. And the legal representative is, if he has to bear for the cost of the policyholder, then he may have an interest not to fully pursue the rights of his policyholder. And that is a conflict which the Federal Supreme Court says does not allow for that a company to provide legal services. Since then, only in Germany, we have this section 4, and legal protection insurers are out of the game. They are not allowed to provide legal services, which is a situation which is, of course, sad for legal protection insurers. So it seems that we have the perfect system in Germany, only lawyers at play. So for consumers, the best country you could think of, but what could possibly go wrong? Well, everything. Is there maybe an issue with access to justice in Germany? There was a study from 2013 by the GDV, that is the German Insurance Association, and they found that 70% of the population prefer not to go to a lawyer, and in the age group of 19 to 28 years, it's 80%. So 80% of the young people say we would not go to a lawyer because, you know, it is for all sorts of reasons, but money plays a major role. The number of cases filed in civil courts is declining, and no one really knows why that is the case. Because on the other hand, e-commerce has increased by 10% in each of the last few years. So, and companies like PayPal, eBay, and Amazon provide their own dispute resolution tools and services. So obviously that is far more attractive than the judiciary. And then headline-grabbing cases like the diesel cases from Volkswagen, or the cartel cases, whether it's sugar cartel, whether it's a railroad, whether it's lorries. It seems that Germany is full of cartels. I'm sorry to say that, but these cases are no longer pursued individually by individual plaintiffs or claimants to go to court, but there are companies, debt collection companies, who collect those cases, bundle them in a sort of class action, and then go forward. So they file, say, 16,000 claims, they bundle them together, and that seems to be very attractive. So the question is the traditional system of the judiciary unsuitable for many typical consumer claims? We call them Streu- and Bagatellschäden. So these are low value damages, and those damages where, you know, you produce one good or one service, and the damages are just spread around. That is what we call Streu- and Bagatellschäden. So there seems to be a certain problem of rational disinterest. So a combination of reasons where people don't go to lawyers and rather step back and waive their rights. So, and what has legal tech got to do with it? It seems that today legal tech is a synonym for consumer protection and for access to justice. Sometimes it's an access to more convenience, but anyway, it's an access to justice because these companies, these non-lawyer services, provide very easy and risk-free services for certain types of claims. So delayed flights, issues with your landlord, insurance cases. There is one claim, Rechtsdurchsetzung, so einfach wie Pizza bestellen. So pursuing your claim is as easy as ordering a pizza. And we all know life is not that easy if you go to a lawyer. It's not as easy as ordering a pizza. And in particular, it is expensive. And under German rules, you are never free of the risk. So if you lose your case, you still have to pay for the other side, because we have in Germany the concept that the loser has to pay the costs of the lawsuit. So there is, of course, always a risk. Even if your plane is delayed, there is a risk that there was a sort of force majeure, so that the airline carrier can't be forced to pay. And these service providers make it easy because they offer it via the internet, and your services are as far away as your smartphone is. You can be a pure couch potato sitting at home and pursue your claims, and there is no risk related to it. Now, this is very good for consumers, and in these areas where these companies are offering their services, there is no chance for lawyers even to try to compete. I mean, if these companies go to court, they need lawyers to instruct, but these are very specialized law firms, highly specialized, completely technology driven. It's not, you don't have 1,000 consumers going to 1,000 lawyers. You have 1,000 consumers going to one legal tech company and then to one law firm. So the situation is slightly different. And for legal protection insurers, that is a real, let me call it a threat, because the interest of a legal process insurer is to have your policyholders turn to you first before they go to a lawyer. And I wouldn't blame them. This is quite natural. So every legal protection insurer has people who helps their policyholders and consumers if they have a question with regard to law. Look, there is someone with my neighbor, with my landlord, with my employer, and so on. And many of these questions can be dealt with on a very low cost level through these legal protection insurers. And that helps them to keep their costs down. And that is natural, and that's a good thing. Now, as legal tech companies are going after the same cases and then forwarding them to lawyers, the situation at the moment is that many legal protection insurers are the sort of financing, the cashier for these business models of legal tech companies who claim the cases, who test whether they can pursue that successfully, and they use software to test that, and then go to the legal protection insurers or their customers and ask them to pay, and they have to pay. So that is a situation which is difficult for legal protection insurers, and many of them have found ways to sort of, in a way which is still allowed, to have a competition with these legal tech companies differently. Many ways to try in Germany, many ways to try to cope with this new situation. So, but before this new law and before the reforms, we had a situation in the legal market which is a sort of perfect storm. We have a very expansive definition of what a legal service is, and we have a very expansive definition of the term debt collection incasso. Because remember what I showed you, whether it's difficult or simple, it doesn't play a role. It is a legal service. So it's reserved to lawyers and these few legal service providers. And then we have, since November 2019, a new decision of the Federal Supreme Court, now from the 8th Senate, who said the term debt collection is not to be understood in a too narrow sense. So that is not just juridical theory. It is actually a legal tech company which is organized as a debt collection company. So they have a license to claim money, and that is basically what these legal tech companies are doing. They have a certain tendency to do more, to claim more, to give legal advice to their customers, to be the first point of contact. That's what legal protection insurers also want to be, the first point of contact. And lawyers are always in the second bench. Of course, legal tech companies try to provide more services, and there was one legal tech company called Weniger Miete, helping people if they have issues with the rent they have to pay, if they claim it's too high. The Federal Supreme Court said, well, if there are ancillary services like advice or some claims only come to life if you sort of claim certain rights. Before payment, you have to claim to a certain right. And the question of these legal tech companies is, why can't we do this? It's not claiming money. It's a sort of precondition for claiming the money. And the Federal Supreme Court says, yes, that's legal. That's part of the license, not just to claim the payment, but ancillary services as well. And in this situation, something had to happen, because you had, on the one hand, lawyers who are competing with legal tech companies, and then in the background, legal protection insurers. But the regulation for legal tech companies is looser and more lenient than for lawyers. For example, legal tech companies may provide or may agree on contingency fees. They may waive their fees, no risk, no fun, and no risk, no fee, and no success, no fee. Lawyers are not allowed to do that. Legal tech companies are allowed to take over the costs of pursuing the claim, which lawyers are not allowed to do. That is process, third-party litigation funding. We call it process finance. So there was no level playing field, and there is no level playing field between lawyers on the one hand and legal tech companies on the other hand. And then you have the legal protection insurers in the back. For them, again, a different set of regulation applies. So in that regard, the new law tried to deal with this. And in the situation today, and all the main disputes were as follows. The first question always was, is there really an issue with access to justice in Germany? So the federal bar is dead against this new proposal. They said there are no real numbers, there is no study on that, and we don't think that the system has broken. It's okay, we don't need this reform. On the other hand, there was the government saying, look, let's acknowledge reality. If people have a choice, they go for the more convenient, less risky option to pursue their claims. And lawyers are not known for being very convenient or less risky, quite the opposite. So let's acknowledge reality. If people take other paths to get legal advice, then let's help them to get that. Have to acknowledge that and protect them on their alternative path. Everything else is just a dog mine. It's not smart politics. Then the no level playing field between lawyers and legal service providers. Then the ambiguity of the term debt collection in CASO. So what is it all about? Are these legal tech companies really allowed to do everything they want to do just because they say, well, it has some sort of connection to payment claims? So even family law matters. Could that be done by a debt collection agency? These are things where you start thinking, well, now, wait a moment, maybe that's not right to do this. And there was a criticism of these bundled mass proceedings, these Sammelklagen, class actions, because the courts of first instance are not yet equipped to deal with these types of claims. They are all of a sudden, people come with masses of paper to the court. These claims have more than 10,000 pages, and you then have attachments, and you have lorries driving to the court and delivering a claim which is not just 20 pages, it is 20,000 pages. And and then you have 3 judges in one court chamber having to deal with 20,000 claims. That would really bury them. No chance to adapt them. And then there came criticisms, and the courts of first instance, it seemed to me and to some other people that the criticism was very gratefully received, and they said, well, that is not part of the Legal Services Act, that debt collection companies come here and pursue these bundled claims. And they rejected it. And there are now a number of court decisions of first instance who rejected these claims, and it now all goes to the higher regional court. And it is starting and evolving into a court battle, which is weird, I must say. It is not helping consumers to pursue their claims. It is just a battle on the back of consumers who even are threatened with complete loss of their claims. And finally, this is number 6 in my slide, that's the renaissance of the Lex Legal Protection Insurer. This section number 4, which basically said legal protection insurers are not allowed to provide legal services due to conflict issues. It now said legal tech companies are not allowed to provide legal services because the combination of incasso, so debt collection, and third-party legal funding leads to conflict of interest, and the bundling of claims as well, because every individual claim is an individual claim. If you combine that, someone has to give and someone has to take. So it is just a vast conflict of interest. And this is the situation we are in at the moment. And before that background, the new law comes. And the essential contents of the draft law are as follows. So first, it is the promotion of consumer offers for consumer, but there is an agreement that it clarifies legal issues which have been problematic in many lawsuits, also brought forward by companies as plaintiffs. It introduces, well, not a level playing field, but the first step to have a level playing field by allowing contingency fees. Today it was reported that litigation funding will not be allowed, but contingency fees and no success, no fee. These fee agreements are now legal, which are at the moment illegal or not allowed. Then there will be a more narrow definition of the term debt collection, so that ancillary services which are only really narrowly, tightly focused to support the claim are legal, the rest is not. But generally accepting and clarifying that debt collection and litigation financing is legal. Still a bit of a gray area, but broadly it's legal, and it's legal to bundle claims. That is the most important part in all cartel cases, which means that plaintiff's activity will sort of rise. Legal tech companies need to get the license to provide more information on their business model so that the relevant authorities can better judge on whether that is really debt collection or not. The purpose is that the license, once provided to a legal tech company, can't no longer be challenged in other courts, and that's a real issue at the moment. And this new, this duty to provide more information on your business model should support or protect you later in court. And then some higher requirements for the expertise of Inkasso-Unternehmen, legal tech companies. That shouldn't be an issue because many of these legal tech companies are founded by lawyers. So there has never been an issue with expertise of legal tech companies. The new bill does not provide any specific protection against the loss of claims. That is an issue, but as I said, the law deals partly with that. So it leads to more consumer protection and better consumer services. Then there was an expert hearing in this. When you get these slides, there is a link and you see the list of experts and all experts' opinions, I'm afraid, in German language, and you see the video of the hearing, very funny, but also again in German, I'm afraid. But how was it? It was very interesting. It was a bit contentious because the German Federal Bar, together with their standard academic, Mr. Wolf, they really firmly rejects it. They said this contingency fees impair the lawyer's independence and lead to a worse access to justice. So it's bad for consumers, not good. The German Bar Association, rather unhappy, partly in favor, but not really. Legal Tech Association is generally in favor of the draft. Of course, there are some minor points. And then there were these other 4 independent experts, and I was among these experts, who are generally in favor of the reform, but acknowledging that there are still some bits and pieces where, well, it's not the nirvana of regulation for modern legal services market. So the main criticism is the new law does not create a coherent regime if you look at lawyers and other legal service providers, but only a less incoherent one. But anyway, it's good that we deal with, say, 70 to 80% of the issues, and the rest will follow suit next year following the general election. Now, what about the Lex Rechtsschutzversicherung? You guys from the legal protection, I am afraid I have bad news because that provision, the Section 4, has not been changed and will not be changed, despite of a very well-reasoned motion of the GDV, this German Insurance Association. So it's still the case for legal protection insurers in Germany, just pay. German legal protection insurers in other countries, like in the Netherlands, ARAG in the Netherlands, you see they're very successful there. And this screenshot from YLAX is from Co-op. And what they offer is really, I mean, look at these stores. It's people going there and they, for 60 Schweizer Franken, they get legal advice, and it's a bit, it's like a modern cafe. It's a combination of between Apple Store and cafe, and that is what people want to have. Of course, they don't want just to have a homepage. Sometimes they need someone to talk to, but they want to be clear what their price for that is. And 60 Schweizer Franken, that is digestible. So, but in Germany, that would be illegal, which is a pity. But for this time, I must say, things will not change unless maybe a legal protection insurer would dare to go to court. But that is something which you don't then achieve in the short term, that you would write legal history. These lawsuits really take time. But as part of that reform, I'm afraid, it's not now looking to the crystal ball. Will it all be implemented? Hot off the press, it seems that the coalition parties have agreed to move that forward, but the exact text, the wording is not yet available, and it has to go through Parliament. And let's touch wood, but we only know it once it is through the Parliament. So it is nearly there, but it is not yet there. And this is it for for today. I'm afraid. Let me close my presentation. I was not able to see whether there are any questions in the chat or whether you are still there. Oh yeah, there are still some participants. So I'm very happy now to take your questions.
Thank you, Markus. I really think this is one of the best and most comprehensive overview that I've ever heard about the situation of the regulation of legal services in Germany. And I want to ask first any of our participants whether you have a question. Please, if you have a question for Markus, you just turn on your microphone, if you like, also your camera, and you are free to ask anything. Meanwhile, think about it. Maybe I start with a question because for me, this whole initiative of the government is very hard, half-heartedly, I would say. It is just clinging to the situation as it is, that you say you have the debt collection, and linked to this, you are allowed to give some advice or some legal services, and that's how the legal tech companies started their business in Germany. What's your judgment there? For me, this is really nothing profoundly new. It's not really helping the legal techs. It's certainly not helping legal protection insurers. Wouldn't there be a better way of regulating this? Markus, please let us know, share your position with us.
Well, I mean, it's probably not a secret that in my view, a modern legal market does not start from the perspective of providers of legal services. It always has to start from the perspective of those who need legal advice. And from their perspective, it depends very much on what they really want to have. There are certain claims where people are perfectly happy if they deal everything with a homepage, without any person or with any trusted relationship or trusted advisor. People are happy to do that. And in other regards, people need someone to talk to. So I have a law firm, which is a legal tech law firm, and what we do is we offer only employment law for employees. And of course, we do everything with technology, but people want to talk. If they have an issue, they need someone to talk to, and they still need it in a way that they can afford it, whether they have a legal protection insurance or not. So, and from their perspective, and in my view, I would think the Swiss way of doing it is something which I think is more modern than the German way. But having said that, I have to see where we stand in reality. And the draft bill sort of reflects reality. And in that regard, I think it clarifies certain issues we are having at the moment, and so it achieves a lot. But is it the law which forms the legal services market in Germany for the future? In Europe, certainly not. So Tobias has raised his hand. Yes. I see it on the screen.
I was just going to refer to him. Tobias, please go ahead.
Yeah, thank you, Markus. That was really insightful, and I like your presentation style actually, and your way of giving the handing over the information to us. One question that remains for me is actually, working for law firms that has a commercial business model in terms of also producing legal tech software, and having worked for a law firm that did so. We undertook a lot of effort actually to split the businesses, if you will, and not making anyone aware of providing a commercial business model. So what does the new regulation mean for those kind of law firms then?
Okay, so thank you, Tobias, for that question. Actually, I should add there are two reforms at the moment. Today I only spoke about the new regulation for legal tech and for contingency fee. The second reform, we call it the Great Federal Lawyers Act reform, that allows for law firms to have non-lawyer branches to provide technology-based legal services from there, or have legal technology developed in a, say, affiliate company, and makes things easier in that regard. So I can't go into detail, but all these issues you had in your recent company, and maybe you will have today, will be dealt with in this new reform. And we expect that next week, 9th and 10th June, the Brau reform, the reform of the legal services, no, not legal services, sorry, the Federal Lawyers Act, passes Parliament and passes the Bundesrat, which is the chamber of the countries, and will be in force maybe sometime next year or so. So that will be dealt with. But this new law doesn't deal with these issues.
Okay, thank you.
So the question whether lawyers may use legal technology and whether that is still in line with their professional regulation, that's an interesting question. Whether a lawyer may provide purely technology-based legal services without alerting his clients that all he provides is just software-based and not personally based, that is an issue not yet fully clarified. I have a personal view on that, which is completely irrelevant, but that is still open.
Isn't this question related to what you said at the very beginning, that I don't know whether it's the BGH that's going to rule on the definition of legal services, whether that includes technology-based legal services, and considering that even IT-based legal services are nevertheless initiated by human input. What's your opinion? Maybe I would be interested.
Yeah, that's interesting. Whether an interesting question, whether the concept of a legal services necessarily mean that is provided by a human being, so directly by a human being, be it by telephone or email or a homepage, doesn't play a role. But the argument of the federal bar is, if someone has built the software, that is the human element of providing services then. So it isn't necessary that on the front end there is a human being if a human being was in the back end. That's a very artificial argument, I must say. For me, I mean, what software can do, it can't deal with individual cases. It can be by pure coincidence cover that what an individual want to have. But it's, it's like bespoke tailoring and tailoring off the rack. Bespoke tailoring, that is what lawyers do and what really lawyer legal services do, because they take all the particularities of an individual case into consideration, which does not happen by software. Software can pose certain questions, and if you're lucky, it deals with your case, and if not, then you're not lucky. So in my view, what software does on a very sophisticated level is providing standard solution, but not a solution to an individual case. And therefore, it's not a legal service. And people have to know what they buy. If they buy, say, a draft contract from the internet, then it may fit their needs, but maybe not. In many cases, it will. In some cases, it will not. In family cases, in inheritance cases, it can be very difficult. But what we need is that what I said, we need a perspective from those who need legal advice and not from those who provide legal advice, because their interest between the providers and the clients are naturally different. And if we say this law is to protect those who need legal advice, then we can't just look at lawyers and see how we can make their life easier.
Thank you. One thing that I'm wondering, and this might be particularly interesting for the international community, why do the German lawyers fight so much against contingency fees and success fees? When we look at other jurisdictions, the US, for example, which is a very strictly regulated legal services market, they work with this. The UK works with it. Other countries in Europe work with it. Why are the German lawyers so much against it?
Yeah, well, this is a complicated issue. I mean, to be fair, one should say that contingency fees are not the global standard. It is the case that contingency fees are allowed in many countries, but with certain carve-outs. For example, in criminal law and in family law, in many countries, contingency fees are not allowed. And then there is a difference between contingency fee and quota litis. So, get a part of that what was the successful claim, and that is to start with. So contingency fees is a very complex issue. But your question, why are German lawyers dead against it? My answer is we don't know whether German lawyers are dead against it. What we know is that the German Federal Bar is dead against it. But and that lawyers in the German Bar Association take the view that contingency fees have an impact on the independence of lawyers, because their argument is if you have a contingency fees, you take a personal interest in the outcome of the case. A very simple and simplistic argument. And as I see many countries where contingency fees are legal, which are not any failed states, which have a good and proper legal system, that what we say in Germany is sort of clinging to some tradition, which, there hasn't been any study or survey amongst lawyers whether they are in favor of that or not. And even if, say, 40% of the German lawyers would say we are against it, what is with the rest of the 60%? So with the 60%, or why should certain lawyers not agree on contingency fees? Because a certain group within the German lawyers think that has an impact on their independence. It is like a dogma. It's a dogma by saying contingency fees have an impact on your independence, but don't ask me any more questions. Just believe it. So it goes more towards religion, other than, say, a modern dispute where you really weigh your arguments and say, look, other countries have it and they are still existing and alive. So what's your issue? It's very hard to answer. I would say you should just liberalize it to a certain extent. I think family law and certain other practices are not well suited for contingency fees. But in general, why not? I mean, commercial law firms do it every day. And contingency fees is not just an uprise that you get more if you're successful. It's a decrease of your fee once the deal doesn't fly. So it's to offer fees which depend on the outcome of the case. That is a contingency fee. Should be allowed, because every client, a commercial client, of course, expects that lawyers take risk into account and share the risk of a client. So you you see where I stand, but I can't claim that I'm the majority because I don't know what is majority and what is minority, as there is no reliable sets of data on this.
All right, thank you. Please, everybody, this is again the question to you. Do you have any questions for Marcus? This is the time now. Otherwise, you will be able to get in touch with him via email. You will have his slides, and you will also have the recording of this session. Maybe, is there anybody? No? All right. Then maybe to sum this up, Marcus, when you look at this regulation and when you look at where legal protection insurers stand in the middle of everything, the argument that legal protection insurers are left out from the legal services market is the conflict of interest, basically. Do you think that this will hold in the future in Germany when you see other countries, how legal protection insurers are allowed to operate there? Just one final question.
It is, in my view, it shouldn't be a sustainable situation. In my experience, I would say in Germany, things have a very long life. And I must say, I don't want to hurt anybody's feelings, but legal protection insurers don't enjoy the best reputation amongst German companies. One has to say that. The same with debt collection agencies, who enjoy a terrible reputation. Because we always take the view from them who have to pay. I don't see anyone on the horizon who is not from the camp of the legal protection insurers raising his hand and saying this is a situation which is not tenable. But legally, if you look at the development with company lawyers, with Syndikusrechtsanwälte, and what Syndikusrechtsanwälte are allowed to do, you will come into a situation where you ask yourself, what is the difference between a company working with independent Syndikusrechtsanwälte, which is a legal and introduced system, to a legal protection insurer providing legal services through independent Syndikusrechtsanwälte? Where's the difference? It may well be that in the 60s, the Federal Supreme Court took that view, but today, I can think about more arguments against this position than in favor of that position. But there won't be any political party coming forward and saying we have to do more for the legal protection insurers.
I agree. It's us who has to come forward and defend our interests.
I think
All
so.
right. So, Marcus, I think we are at the end of this extremely interesting session. I really thank you so much for presenting for our members and for other members, for other people as well. ELTA was invited, and basically this was an open session. So thank you very much, Marcus. We'll be in touch, and your slides and everything will be available shortly for everybody.
Shortly, I have to edit them.
Yes, we know.
Thank you guys for all your patience listening to these very special German things. If there are issues, just send me an email and I'm sure I can clarify all these things. Okay?
All right. Thank you very much, and talk to you again soon. Bye.
Bye-bye.